Welcome to Primary Sources. I'm Jason Beets. The U.S. Supreme Court is considering whether to overturn Roe v. Wade, a nearly 50-year-old decision that provides women the right to obtain an abortion prior to fetal viability. The Supreme Court is likely to overturn or limit Roe v. Wade this summer, when it decides Dobbs v. Jackson Women's Health Organization. The Guttmacher Institute, a pro-choice research organization, has determined that 21 states already have laws in place that could allow them to ban abortion if Roe v. Wade is overturned. These states are collectively home to more than 135 million people. These states ban abortion in different ways, and some states have laws that ban abortion in multiple ways. 9 states have laws in their books that were enacted prior to the Supreme Court's 1973 Roe v. Wade decision. If Roe is overturned, those laws would take effect as if the past 50 years of abortion politics in the United States had never taken place. 12 states have trigger laws that would automatically ban abortion if Roe v. Wade is overturned. Most would ban abortion with limited exceptions, for circumstances such as medical emergencies or in cases of rape or incest. 5 states have enacted near-total bans on abortion. These laws, which seek to prohibit abortion under all or nearly all circumstances, were passed after Roe was decided. So far, these bans have been blocked by courts, and none are currently in effect, but that could change if Roe is overturned. Several states have adopted laws that ban abortion after the beginning of embryonic cardiac activity. 12 states have adopted a ban on abortions after 6 weeks of pregnancy, and one state, Missouri, has adopted a ban on abortion after 8 weeks of pregnancy. These laws, which are described as fetal heartbeat laws by their supporters, could be allowed to take effect if the Supreme Court overturns Roe. Only one of these state abortion bans, the Texas ban on abortions after 6 weeks of pregnancy, has been allowed to take effect because the law is enforced through private litigation rather than by state officials. I discussed the U.S. Supreme Court's decision to allow that law, SB 8, to take effect in the first episode of Primary Sources. Collectively, women in these 21 states could lose access to abortion in their home states that they have enjoyed for almost 50 years. Under many circumstances, women from these states would have to travel long distances to access legal and safe abortion services. Today, we're going to examine Missouri's trigger ban, which would ban abortion if the Supreme Court overturns Roe v. Wade. The trigger ban is part of a much larger law, but we will only read the part that explains how the state will respond if Roe is overturned. This section shall be known and may be cited as the Right to Life of the Unborn Child Act. Notwithstanding any other provision of law to the contrary. So right off the bat, we begin with a bit of legal jargon. Notwithstanding is a way of saying despite, or more precisely, what follows does not apply to the rest of what we're talking about. Specifically here, this phrase is saying that anywhere else in Missouri law that might say otherwise doesn't apply to what we're talking about. So, notwithstanding any other provision of law to the contrary, no abortion shall be performed or induced upon a woman except in cases of medical emergency. Which begs the question, what does the state of Missouri consider a medical emergency for the purposes of this statute? Missouri defines a medical emergency, in this context, as a condition which, based on reasonable medical judgment, so complicates the medical condition of a pregnant woman as to necessitate the immediate abortion of her pregnancy to avert the death of the pregnant woman, or for which a delay will create serious risk of substantial and irreversible physical impairment of a major bodily function of the pregnant woman. So, under this law, an abortion would only be allowed if it was necessary to save the life of the pregnant woman or in order to prevent serious physical injury to the pregnant woman, as defined previously. And that's it. There are no exemptions to the abortion ban for rape or incest, which appear in other abortion bans. So heading back into the text of the Missouri trigger ban, notwithstanding any other provision of law to the contrary, no abortion shall be performed or induced upon a woman except in cases of medical emergency. Any person who knowingly performs or induces an abortion of an unborn child in violation of this subsection shall be guilty of a Class B felony, as well as subject to suspension or revocation of his or her professional license by his or her professional licensing board. A woman upon whom an abortion is performed or induced in violation of this subsection shall not be prosecuted for a conspiracy to violate the provisions of this subsection. So here we see a situation that is common throughout a lot of anti-abortion legislation in the United States, which provides penalties to a doctor who provides abortion, but not to the woman seeking an abortion. A doctor who performs an abortion in violation of this statute would be guilty of a Class B felony, which would prevent doctors from offering those services, at least openly, because they would be doing something illegal for which there are serious potential criminal penalties, which would effectively prevent the woman seeking abortion from having the right to choose to have an abortion, even though she herself would not be subject to the criminal penalties laid out in the law. It shall be an affirmative defense for any person alleged to have violated the provisions of subsection 2 of this section that the person performed or induced an abortion because of a medical emergency. The defendant shall have the burden of persuasion that the defense is more probably true than not. So here we see that if a doctor was prosecuted for carrying out an abortion in violation of this law, he or she could argue to the court that he carried out the abortion in the context of a medical emergency as defined by the law, and if he and his lawyer are able to convince the court that that is indeed the case, then he or she would not be liable for carrying out the abortion. But that's an awful lot of legal risk to take on, even if you think that it is necessary to prevent serious damage to the health of a woman who is seeking an abortion. The enactment of this section shall only become effective upon notification to the Reviser of Statutes by an opinion by the Attorney General of Missouri, a proclamation by the Governor of Missouri, or the adoption of a concurrent resolution by the Missouri General Assembly that. So, before we go on, the mechanism by which the notification to bring this statute into effect would come from either the Attorney General of Missouri, the Governor of Missouri, or the Missouri General Assembly, which is another way of saying the Missouri Legislature. A concurrent resolution referring to a resolution passed by both chambers of the Missouri Legislature, the Missouri House and the Missouri Senate. So one of those three institutions would have to notify that one of the three circumstances had occurred. The first of which would be that the United States Supreme Court has overruled, in whole or in part, Roe v. Wade, 1973, restoring or granting to the state of Missouri the authority to regulate abortion to the extent set forth in this section, and that as a result, it is reasonably probable that this section would be upheld by the court as constitutional. So, if Roe v. Wade is overturned by the Supreme Court, then this law could take effect, and that's something that is very much a possibility in the coming months. 2. An amendment to the Constitution of the United States has been adopted that has the effect of restoring or granting to the state of Missouri the authority to regulate abortion to the extent set forth in this section. So if the Supreme Court doesn't overturn Roe v. Wade, but the United States Constitution is amended to overturn Roe v. Wade, then that would also trigger this law into coming into effect if one of those three institutions notifies the Reviser of Statutes that it has occurred, Or 3, the United States Congress has enacted a law that has the effect of restoring or granting to the state of Missouri the authority to regulate abortion to the extent set forth in this section. So, if the U.S. Supreme Court overturns Roe v. Wade, the Constitution is amended to overturn Roe v. Wade, or Congress enacts a law that provides Missouri the authority to enact its trigger ban, then the Attorney General of Missouri, the Governor of Missouri, or the Missouri Legislature can notify the Missouri Reviser of Statutes that the trigger ban is in effect. So, Missouri's trigger ban would ban abortions with the exceptions when a woman's life is in danger or when an abortion is necessary to prevent serious physical injury to the woman. And that's it. There is no exemption for rape or incest, which means that if Roe is overturned and this law comes into effect, if you're a woman in Missouri and you're raped, then it would be illegal for a doctor to provide you an abortion unless that abortion were necessary to save your life or to prevent serious physical injury. Otherwise, you're going to have to travel to another state where abortion is legal or receive an illegal abortion from a doctor who's willing to put up with the legal risks of carrying out what is a Class B felony under state law. We are once again on the verge of a time when a woman's right to access safe and legal abortion services will vary significantly from state to state, depending on the beliefs of voters and politicians in each state. I'm reminded of the patchwork quilt of state laws governing gay marriage prior to the U.S. Supreme Court's 2015 decision in Obergefell v. Hodges that allowed same-sex couples to marry nationwide. By and large, I believe the Supreme Court's jurisprudence in Roe v. Wade and Planned Parenthood v. Casey is correct. More importantly, these cases created a uniform set of guidelines for states that allowed women to access safe and legal abortion services nationwide. Women could reasonably predict they would have access to pre-viability abortions, regardless of what restrictions conservative lawmakers tried to enact in their states. Now, the right of women to make one of the most difficult and personal decisions in their lives, a decision with far-reaching implications for their families, careers, finances, and futures, might soon be taken away from them in large swaths of the country. If Roe is overturned, the implications will be far-reaching, profound, and immediate. We are only months away from seeing if the decades-long push by the conservative movement to overturn Roe will succeed. If it does, we will witness firsthand what the U.S. will look like without basic federal protections for abortion rights. Next time on Primary Sources, we will examine the near-total abortion ban approved by the Oklahoma legislature and consider its implications for Texas women seeking out-of-state abortions following the enactment of the Texas abortion ban.